submitted by Baxter and Woodman Consulting Engineers for services to assist the city of West Dallas in performing an optimized corrosion control treatment study for the amount of $18,000 ordered by the Wisconsin Department of Natural Resources.
Move for approval.
Second.
Moved by Alderman Lysick, seconded by Alderman Ranky. Is there any further discussion? All in favor?
Aye.
Opposed, carried. Number 8, resolution authorizing the purchase of hardware, equipment, and services which support the mobile use of Assist Works work order software for the sum not to exceed $12,000, amending the use of the funds approved by the capital improvement request pursuant to Resolution R 2018-0494, adopted July 17th, 2018.
So this is funds that are to be used for iPads, and we have the AssetWorks software, so we're starting the implementation next week. And Tony and his staff is helping the Department of Public Works, so this would help us have that mobile capability.
Move for approval.
Second.
Moved by Alderman Lysick, seconded by Alderman Stefanski. Any further discussion? All in favor?
Aye.
Aye.
Opposed, carried. Number 14, ordinance to amend section 11.114A, 11.115A, 11.119, and 11.183, and create section 11.20 of the West Dallas Revised Municipal Code relating to installation and maintenance of small wireless facilities.
Mr. Chair? So this is a draft ordinance that I created because a law was passed in July 10th, 2019, in which the state decided that they were going to be imposing certain types of regulations and restrictions and creating a standard for which small cell towers or small wireless facilities are going to be installed throughout the state. There was an FCC order prior to that, so on the federal side, this was coming. The state then enacted something that was quite similar, a little more restrictive against municipalities, but relatively similar. And so as a result, it is part of that law that requires every municipality to enact an ordinance by October 1st of 2019, enacting whatever regulations the city deems to be proper. So what I did is I essentially took what was in the law, worked with the city engineer to try to come up with a draft ordinance that complied with the state law, but also gave as much discretion to the city as the law allowed, so that at least the city engineer would have some say in the location of these items, how they're constructed, where what they appear to look like. But of course, the state law is somewhat restrictive on those options, so there's not much that the city could do to top the height of these things or impose certain restrictions that would make them technologically or technically infeasible. So for the most part, these devices are coming, and then it's just a matter of fine-tuning their location and working with the providers on how these things can actually be located. And for those who don't know, the small wireless facility or small cell, as a broad overview and overgeneralization of the topic, it is a smaller electrical device that receives and sends signals to any type of mobile devices. It operates much like the very large towers you see, except they are very small and located in close proximity to their users. What it does is it significantly magnifies the speed at which data can be transferred, thereby increasing all the speed of the devices they're working with. It's commonly known as the precursor to the 5G system.
Mr. Chairman,
Alderman Lysick.
could somebody explain how big these are, how high the towers can be? Can they be in residential areas, or are they going to be, so our residents can understand when these come, what to expect?
Sure.
About 30 feet tall at the most?
What I've been informed, I've talked to reps from AT&T and Verizon on this, and generally 30 feet is sort of what their engineers deem as to be the sweet spot for maximizing efficiency without going too high.
How high is a light pole?
20.
20, so 10 feet higher than the street lights.
That's a common number, although it varies with each location. Their engineers have very specific formulas to determine where the locations of these things should be and what their height should be. It's pretty incredible science from what I've learned. But, yeah, so and there's a height restriction within the state statute anyway. So regardless of what the city wishes to do, the statute allows the poles to be up to 50 feet tall. And yes,
How far apart are they?
generally, they can be, depending on the usage, a block or two or several blocks. It really depends on the coverage that the provider deems necessary. And to answer your other question too about residential areas, they can be installed in residential areas. One of the location requirements that has been imposed was that we would seek to have providers install them at intersections or coterminous lot lines so that they are installed as frequently as possible in spots that aren't necessarily within people's visibility. So two adjoining lots, we try to get it in the right-of-way on that line if possible, rather than in front of houses. But of course, everything is subject to the state law restrictions regarding technical feasibility.
Okay, thank you.
Mr. Chair.
Yeah, Alderman.
Yeah, Carol, what about if we act tonight, it makes a difference to vote on October 1st? So what's the reason?
So the state law requires the city to have in place standards by October 1st. The reason that I put on this agenda now is because I didn't want to drop it on the council on October 1st and force you into doing it that night. I thought today would at least be an option so you could read it through, answer some questions, talk things through, and see if this is a version that you want to pass tonight, or if there's any reason to delay it, we could do that, and there would still be an opportunity to pass it on October 1st at the next meeting.
So I mean, in many ways, by the state's laws and statute, we don't have much recourses, right?
There are a lot of restrictions in the state law that limit the city's ability to impose requirements upon wireless providers, yes. What this does is it, essentially aesthetics is the only part that has a little more leeway, and so you'll see a lot of aesthetic regulations in this particular version. That was really the only spot where there was sort of an opportunity to at least put in some regulations. But other than that, a lot of it is already set by statute, and the options for the city engineer are quite limited.
Who
Mr.
made
Chair,
the motion of approval, really?
Mr. Chair,
Yeah, Alderman Stefanski.
is there any kind of data, information, research on any kind of health risk to any residents if we put them in residential areas?
The providers themselves have shown me and explained to me a lot of data indicating that they're not a health risk, especially in the way that they're going to be installed. Just like any other radio frequency or any type of frequency that's occurring at any hertz level, if it's something that is very, very powerful and it's very close to you all the time, any level of frequency can be damaging. But because they're installed high in the air and because they're not installed permanently next to somebody, the frequencies, from what I'm told, are not harmful. Or at least there's no signs to say that they are harmful at this time.
Okay.
Mr. Chair,
Yep. Alderman Rainey.
will there be any protections for neighborhoods to have these
What sort of
neighborhood?
protections, as in?
Yes.
Um,
I mean,
We have all these aesthetic protections, if that's what you're.
okay,
Are you
So
talking
the-
like health risk type of
Replacement
things?
protections.
Are you talking like health risk type of things?
yes,
Oh, that way.
health-wise.
Given that I'm not aware of any specific health risk that they pose, I don't know what additional protections would be necessary. As far as their aesthetics, where they're located, what they look like, that really is where the city can impose some regulations. And even then, it is still subject to a state law that essentially allows the provider, if they can show that it becomes technically infeasible to comply with the regulations, then those regulations don't apply to that particular installation.
So the state law hasn't addressed the health aspects of it? It doesn't sound like.
There is one portion of the state law that talks about I think it's the RH or it's an RF intensity guide or something along those lines. I actually don't know much about the technical side of it, but there is something that basically makes them certify that is not hazardous to human health.
Well, didn't you have that in the ordinance too?
Yeah, I don't know if I put it in here or if it's just in the state law that I was relying upon. Okay, so if you look at the end of Part 2, if you have it printed out, it just simply says the applicant of the small wires facility must certify that the facility will comply with relevant FCC regulations concerning radio frequency emissions from radio transmitters and unacceptable interference with public safety spectrum, including compliance with abatement and resolution procedures for interference with public safety spectrum established by the FCC. Basically, say they're not going to interfere with public safety radios. Also, will not interfere with the safe operation of traffic control equipment, sight lines, or clear zones for transportation or pedestrians, ADA, or other federal standards. So they do have to certify to those things as well.
Thank you.
Mr. Chair,
Alderman Stefanski.
it appears that we don't have much say about this within the city limits. So if we find out down the road that it can start causing health hazards to people, does the city have any kind of, that they can issue something, or they can take care of it or stop it or anything like that? Do we have that capability?
Well, obviously, this is a new law and hasn't been tested this way, but the theory would be that regardless of what a state allows or does not allow, common law public nuisance is always an option. So if there's a threat to the health of the community, generally public nuisance law is what you would apply to enjoin that. And so if good, solid evidence comes out that allows the city to prove a case like that, that's likely where I would go with it.
Okay.
Regardless of what the law says.
Okay, thank you.
I made the motion to approve.
I'll second it.
Motion by Alderman Vitale, seconded by Alderman Lysick. Any further discussion? All in favor?
Aye.
Opposed? Carried. Number 15 on tonight's agenda, resolution accepting the work of Payne and Dolan Incorporated for street construction on West Lincoln Avenue from Union Pacific Railroad to South 61st Street, and authorizing and directing settlement of said contract in accordance with the contract terms of the 2017 project number 8 for the final payment amount of $7,250.10 of the $1,281,061.59 total project cost.
Motion to approve.
Second.
Moved by Alderman Stefanski, seconded by Alderman Ranky. Any further discussion? All in favor?
Aye.
Number 16, communication from the city engineer regarding the 2020 special assessment rates.
Place on file.
Moved by Alderman Vitale to place on file. Is there a second?
Second.
Seconded by Alderman Ranky. Any further discussion? All in favor?
Aye.
Opposed? Carried. That concludes Public Works. Motion to adjourn.
Second.
All in favor?
Aye.
Opposed? Carried.
Yeah, we put a note that 8 years ago, October 1st stop.
Oh, okay.
Yeah, because people didn't like the idea of having a playground by the parking lot in the back. Only 14 were against, there's only 42 residents there,
problem.
you know, I mean,
Okay.
but we'll see what happens now.
Safety and Development meeting will come to order. All members of the committee are present. Two items tonight. Number one is item 17. It's the ordinance to create section 10.23 of the RMC relating to operation, parking, and rental of electric scooters. This is the ordinance that we discussed at the committee of the whole earlier this evening, and I believe there are some amendments. Attorney Decker, if you could.
Can do that. So from the version that was attached to this one, the few amendments were made or at least suggested at the committee of the whole meeting. Those amendments include removing from 10.231B the reference to the bicycle way, thereby making it only unlawful to operate an electric scooter on a sidewalk, but they would be allowed to be operated on a bicycle way. And then adding under section 10.23 sub 2, D, or C is numbered to letter D, and C is added at the suggestion of the people who were at the meeting, that no person may park an electric scooter in a manner that obstructs a crosswalk or access to a crosswalk, a driveway or private road, or a carriage walk. And that, again, adds on to the restriction that says folks cannot park them on a sidewalk in a manner that obstructs a 4-foot path. So if if you're going to have a scooter in the city, you have to leave a 4-foot wide path on any type of sidewalk. And you also may not obstruct at all in front of those locations. The penalties were also adjusted from the version that was published. So under Part 2, every penalty, the minimum was increased to $25 plus any fees or surcharges imposed by state law.
Then to clarify for all the committee members, if we pass this ordinance, it precludes the rental of scooters in the city for the present time. And the committee of the whole said that this issue could be revisited next spring if we felt that there was a need to allow the rental at that time. But for now, it is going to be not allowed to rent them in the city.
Mr. Chair? And to clarify for anyone who is watching, basically, if this is enacted, it would allow individuals to own their own scooters, and it would allow them to operate them on roadways as long as it's a 25-mile-an-hour speed limit or less. But that's really where they could be, and they could be parked on sidewalks but not ridden on sidewalks. So those are the big restrictions that people should know about if this is passed.
Mr. Chair,
Alderman Vitale.
would be logical for us to really hold this ordinance at this time until, like Alderman Lysak mentioned, the rental in the spring, when spring comes, and we just hold it until see what happens within the other communities just as well. I don't know if it's a good idea, but I tried to address that, you know.
If this item was held and not voted on tonight, then the state law would be all that controls, and the state law currently allows operation on sidewalks, it allows rental companies to operate.
Yep.
So the only way to prevent that would be to enact something, whether it's tonight or later.
Mr. Chairman?
Alderman Barzak.
My understanding, there were 3 fees that we had to discuss. I know you mentioned one of them. One was 0 to 100, one was to $25, and the third one was up to 1,000. And the first one, which I think was, if you would help me with that one?
Yes, that was for any operator violations. So if someone was riding a scooter on an area that was a 35-mile-an-hour road, or if they were riding on a sidewalk, then the total forfeiture amount would be $25 to $100.
And my recommendation on that, let's go like right in between at 50. The committee agrees with that?
I have no problem with that.
I would hope, Alderman Barzak, that there would be a learning period. I think that, number one, I don't think there's a lot of people in Waselles that have them right now, with the exception of Alderman Weigel. But I don't think you're gonna see a lot of operation, and those that we do, I think I would like to see the police department issue a warning ticket first to kind of get people familiar with what the rules and regulations are, because there's gonna be a lot of confusion. This is a brand-new thing for all of us, certainly new for our residents, and so I think once we get residents up to speed on what the rules and regulations are, then I have no problem with raising the fines and that, but I think in the beginning at least, keep it down and reasonable, and I think we want to educate the population first, rather than start beating them over the head.
So 25, or,
Yeah, I think 25 is reasonable.
and then the second one, like 15? Or 10?
The parking violation was gonna be 25.
Was gonna be 25,
Yeah,
so
25.
25, 25, and then
25.
the last one was, that one had me a little confused on why that one was up to 1,000.
So the reason I proposed it going from from $25 up to $1,000 was because it has to do only with the short-term commercial rental violations. Someone operating a scooter and someone parking a scooter, there's no real financial incentive to violate that law, but to rent out a scooter, there's a financial incentive. So I wanted to ensure that the forfeiture could be high enough to discourage that behavior, depending on how profitable it is.
Okay, so that would be from the actual company that may come in here and do it without our permission.
Correct, because that law says no person may engage in the business of short-term commercial rentals. So it's the person operating the company.
Yeah, that sounds,
What dollar amount?
That one's $25 to $1,000.
That's the current amount that's been in the draft, but if there's a will to change that, it can be changed as well.
it think our Judge Murphy has the option of,
Well, he has the option then from 25 to
Yeah.
1,000, he can
Right.
assess that fine.
right.
Correct, so,
Got
the-
it.
yep.
And he has good judgment, and I'm sure he'll,
Right?
So it's just simply a range. It is not the amount that
Very
would be
good.
necessarily charged.
what's your pleasure?
Move for approval?
Second.
Amended?
Yep.
First,
Move for approval as amended.
Second.
we should probably vote on the amendments first.
To ensure that it happens, yes.
Yeah, so let's make the motion to approve the amendments.
Motion is to approve the amendments as stated.
Second.
Any discussion? All in favor, aye?
Aye.
Opposed? And then on the ordinance as a whole, as amended?
Move to approve as amended.
Second.
Any further discussion? All in favor?
Aye.
Alderman Stefanski. Opposed? Passed as amended. Thank you, Attorney.
Thank you.
Thank you.
Item 18, ordinance to amend section 6.027, sub 2, sub C of the RMC relating to definition of designated offender. And this has to do with the sex offender ordinance. There was a miss in there, or Chief, you can explain it better than I can.
So in the current ordinance that was passed a little over a year ago, there is, in an interpretation from the city attorney's office, we have to very narrowly interpret, and the current ordinance may not have impact against everyone that we would like it to have impact against. And I'll give you the best example. You have a case that the district attorney starts out as a crime against a child. It's a first or a second degree sexual assault. And for a variety of reasons, the district attorney plea bargains that case to something that is not a first or a second degree sexual assault. A reason to do that could be you want to spare the victim the process of having to testify in court. There could be issues with the case that we present to them. There could be issues with witnesses. So there's a variety of reasons why a DA may wish to plea bargain something down to a lesser offense. However, for purposes of our ordinance, we're interested in the conduct that the suspect engaged in, not the conclusion that a court ultimately reached. So the technical changing in the ordinance that is in front of you today allows the police department, in close consultation with the city attorney's office, to look at the conduct that occurred as opposed to just the outcome that the court reached. So if we get someone that clearly engaged in a sexual assault against a child and it's plea bargained down to something less than that, we will focus on the event that actually occurred and not the conclusion or the final outcome. So it, if passed, allows us to engage with people as to where they can live based on the conduct that they engaged in. And I think ultimately it protects the city better than the current wording of the ordinance.
Thank you.
Did I explain that correctly?
Couldn't have done it better myself, Chief. Sound like it, my goodness.
Mr. Chair.
Alderman Vitale.
Chief, I like what you said, the way you can make more or less decision where the offender could really live, you know?
Yep.
Because right now, really, is not the case.
Yeah, and the current ordinance is a sound ordinance. It opens up plenty of areas of our city for folks to live, but it also protects the areas that children are most likely to be present at. So the current ordinance is a very good ordinance. I believe it helps us on legal aspects. If we were to get sued, I believe that we would prevail. And we just want to be able to apply it to the right people.
Move for approval.
Second.
Been moved by Alderman Vitale, seconded by Alderperson Ranky. Any discussion? All in favor?
Aye.
Opposed? Carried.
Thank you.
Mr. Stiebel, is there anything else to come before the committee?
Move to adjourn.
Second.
All in favor?
Aye.
Aye.
Opposed? Carried.
We have to wait for Alderman